Hi everyone, welcome to Lawyer Up by NDV Law. I'm Attorney Karlo Nicolas, Senior Partner of Nicolas and the Vega Law Offices. Today, we are going to discuss about how to amend your Articles of Incorporation with the Securities and Exchange Commission of the Philippines. The Articles of Incorporation is a Bible of any corporation. It spells out the pertinent information concerning the name of the company, the primary and secondary purposes of the corporation, the principal office of the company, the term of existence, the names, nationalities, and residences of the incorporators and directors, authorized, subscribed, paid up capitalization of the company, the corporate treasurer, among many others. It bears great emphasis that there is a proper procedure for amending the Articles of Incorporation in the Philippines. Any revision cannot be done by mere corporate memo or notice. Therefore, should one wish to change or should you want to change the corporate name, principal office address, number of corporation directors, purpose of the corporation, compliance with the provisions of the revised Corporation Code is mandatory. To summarize the law, there are three basic requirements for amending the Articles of Incorporation, namely, majority vote of the directors, 1, written assent of the stockholders representing at least 2/3 of the outstanding capital stock, number 2, and third, approval by the SEC of the amendment. Regarding the first two amended requirements, a meeting must be held, whether it be during a regular annual meeting or a special meeting called for that purpose. Now, the rules regarding such meetings, for example, the notice, the time, and the place, these should be found in the corporate bylaws of the company. The meeting of the stockholders must first take place, and the issue of the amendment must be assented to by the stockholders representing at least 2/3 of the outstanding capital stock. Thereafter, it must be approved by a majority of the board of directors and duly certified by the corporate secretary. Now, to prove that all of these acts happen or have been complied with, you need the following documents. Number 1, the resolution of the stockholders. Number 2, a resolution from the board of directors. Number 3, the director's certificate. And finally, the secretary's certificate attesting to all of these. These documents, together with the amended Articles of Incorporation, must be submitted to the Securities and Exchange Commission. Now, if the amendment refers to the purpose, and this requires a secondary license from another government agency, then the endorsement or license from such government agency must also be submitted to the SEC. If there's an increase in the authorized capital stock, a treasurer's affidavit and the corresponding bank certificate of deposit must be submitted to prove such fact. The amendment of the Articles of Incorporation may be disapproved or even rejected if it is not in compliance with the revised Corporation Code. Fortunately, the SEC will allow the corporation a reasonable time to correct or modify the objectionable portions of the articles or amendment. Now, here are some of the reasons why an amendment of the Articles of Incorporation may be rejected. First, if the Articles of Incorporation or any amendment thereto is not substantially in accordance with the form prescribed by law. Number 2, if the purpose or purposes of the corporation are patently unconstitutional, illegal, immoral, or contrary to government rules and regulations. Number 3, if the treasurer's affidavit concerning the amount of capital stock subscribed or paid if it is false. Number 4, if the percentage of ownership of the capital stock to be owned by citizens of the Philippines has not been complied with as required by existing laws or the Constitution. Number 5, if the application for amendment is not accompanied by a favorable recommendation or endorsement from another government agency to the effect that such articles or amendment is in accordance with law, if the amendment is one which requires the corporation to secure a secondary license. Now, if the corporation finds out that the amendment is in order, it shall issue a corresponding certificate of amendment of articles of incorporation. It is worth emphasizing that if a corporation does not properly amend its articles of incorporation, the corporation may be penalized by the SEC with an initial fine. We have now discussed how to amend your articles of incorporation with the Securities and Exchange Commission in the Philippines. If this video has been helpful to you, kindly hit that subscribe button. Also, please visit our Facebook page and our website ndvlaw.com for a wealth of legal resources. Again, this is Attorney Karlo Nicolas of Nicolas and the Vega Law Offices, and thank you for watching Lawyer Up by NDV Law.